special audit of the Transport Authority human resource and administration practices, as well as procurement transactions for the period 2017 to 2022. And that was in response to several allegations outlined on page 6 of our report. We sought to assess whether the authority had breached its own HR practices and policies, as well as GOJ procurement guidelines. Whereas we identified weaknesses in the systems of internal control related to HR and procurement practices, we saw no evidence that supported other allegations in this report, including improper awarding of contracts. At the same time, we did not pursue allegations regarding hackney carriage licenses, given the size of the hackney operations or limited resources, and the fact that the allegation would be better investigated by an anti-corruption agency with powers to prosecute. The key findings of our report are reflected in the prompt, as well as, of course, in the first 3 pages of our report. Thank you.
Thank you. Madam Pierce or the Managing Director, I don't know which one of you will respond on behalf of the agency. This is a general response, and then there'll be specific questions after.
I will yield to the MD, sir, given that...
One second, Madam Pierce. Yes, Member Guy.
Thank you, Chair. Before the Ministry and the Transport Authority does their presentation, I had not seen within the report here about, unless an oversight on my part, about the hackney carriage position, and hearing the report of the Deputy Auditor General that it is because of the widespread, well, not widespread, but the extent of the hackney carriage operations, that it will be best looked into by an anti-corruption agency. Have recommendations been made from the Auditor General's Department to have that done?
I would say, though, I know I read that particular recommendation, or the conclusion that you could not pursue it because you didn't have the resources. But I would invite you to respond to Member Guy.
Okay, in terms of the allegation, I am not aware that the Auditor General has yet advised any anti-corruption agency. However, I am sure that in due course, if necessary, she will.
All right. Mr. Managing Director.
Thank you. Just to say, Chairman, that the Transport Authority is in receipt of the Auditor General's report. We have reviewed the content therein, and there are a number of recommendations that we are looking into.
You're going to have to speak up a little more, just for... There
are a number of recommendations that are contained in the report, and we are currently looking into those recommendations. There's a particular matter as it regards the payout, a severance package for our former managing director, who at the time was general manager of operation, and that matter is sub judice, and therefore the Transport Authority will await advice from the Attorney General in respect of how we proceed in that particular matter.
All right. Let me start in terms of questions by highlighting the point raised by Member Guide in relation to the allegations of, I believe, sale of hackney carriage licenses. And the Auditor General indicated it would have been outside her scope. Has the Transport Authority engaged either the JCF, MOCA, or any other entity to investigate these allegations?
No, not at this time. The Transport Authority has not engaged any of those entities to look into the matter, but I'm certain that is something that down the road we're prepared to ensure that our processes are above board, and therefore we will invite any anti-corruption agency that can assist the Transport Authority in getting to the bottom of this particular challenge.
Let me ask you, from your own assessment, do you believe this to be an issue, the allegation which was this specific allegation?
The challenge with that is that we don't know whether or not this particular act of corruption, as it is perceived out there, is inside or outside the authority. And that is one of the things that we want to get to, as to whether or not there's a scheme on the outside, or whether or not there are any persons within the organization itself that would be part and parcel of this whole arrangement.
Have you done an internal review to satisfy yourself about whether anybody within the organization would be participating in something like this?
We have done our own reviews. One of the things that we have started to do is to reposition all applications for Hackney Carriage before the licensing committee, just to ensure that that process is observed in full.
Could you, for our benefit, just indicate what the process is from someone who starts, who has an interest, and what you have to go through until approval?
Okay, so what is required in terms of the entire application process is that a fit and proper account of the operator is taken into consideration. So a police record is required of the individual. Also, recommendations from Justice of the Peace, Minister of Religion, etc. An L form would be required for the fit and proper nature of the vehicle in question, and documentations for the vehicle in respect of the fitness, registration, insurance, proper identification, TRN, and a payment fee of $15,000. And that payment fee is a non-cash transaction. So it's done either by a debit card or a credit card transaction, or the applicant can pay through Bill Express or Paymaster.
So there's no exchange of cash anyway?
No exchange of cash. That's our system. And the applicant could come to the authority and submit that application. For the most part, the Hackney Carriage operators are aligned to taxi companies and different organizations. And what we hear on the outside is that what is being touted as corruption may be related to that side of the arrangement, when they have to go through a middleman to get a license.
What is generally the average turnaround period from an application till approval?
10 working days is a standard for the Transport Authority. The Transport Authority also provides express services. So if the applicant wants to pay for a same-day service, 24-hour service, it's an additional $5,000. And if the applicant chooses a 3-day turnaround time, it's an additional $3,000 charge.
Okay.
Mr. Smith, can you tell us the process and what's the difference between a Hackney Carriage license and a route taxi license, if there is?
All right, so the processes are not very dissimilar. It's kind of linear in terms of their requirements. The difference, however, is that the route taxi is a stage carriage B, and it operates along a particular line of route, picking up and setting on passengers at separate fare. So separate fare is a characteristic of a route taxi, a stage carriage, as well as an express carriage. A Hackney carriage ought to be operated as a whole, so it's more or less a chartered service. So the law requires a use of that particular vehicle as a whole. So that is to say, one or more persons going to a common destination and they charter the vehicle, and at the end of the journey, they would pay for the service rendered.
Well, before I go back to member guy, to the public, how would the public know the difference between, because both of them are red plate same way, right? Do they have a specific sign on the vehicle? Because don't they charge different fares too?
That's correct. So what distinguishes both is that both wear a checker. So for the Hackney carriage, it's an orange and black checkered, and for the route taxi, it's a black and white checker. The route taxi is denoted with the association's logo, and it's clearly marked route taxi. The destination marking is on it, so it will tell you from Poppin to Halfway Tree, that's a route, or from Washington, from Normal Manley Gardens to Halfway Tree, that's a route. The Hackney carriage doesn't have a route, so it marks Hackney carriage. So that distinguishes the two types of services. One of the things we want to do is to, in order to make it clearer to the public, the difference between a Hackney carriage and a route taxi is to rebrand the Hackney carriage or the route taxi, especially in respect of the color-coded street, because for many there's a confusion. Both are checkered, one is black and white, the other is orange and white.
Before I go to member guy, and what is the difference in the fares for both?
All right, so the route taxi is calculated per kilometer, and currently the base rate is $13 plus an additional per kilometer rate. So it is charged $7 per kilometer. So the base rate is applied the moment the passenger is seated inside the vehicle, and then the per kilometer is added based on the distance traveled. For the route taxi, they start at a much higher level, and the per kilometer rate is $45 per kilometer. So in terms of the application of calculations, it's one and the same. It's just that one is higher than the other.
Member Guy, then member
Thank you,
Cousins.
Chair. Mr. Smith, you mentioned, as it relates to the suggestion of corruption in the system, that so far your investigations are based on what you've heard, it is outside, and you made reference to the other associations that they have. Well, you said the talk out there is that. But the talk also is there out there is that the operators of route taxis have, part of the corruption is that they have to be paying as much as up to $600,000 for a route taxi license. Yes, talk is out there about that, sir. I'm surprised you haven't heard that. And that this is part of the corruption that they're speaking to. You mentioned that, as far as you're aware, it is only the Hackney carriage that this particular thinking or thought or allegations are being made, but it also involves route taxi operations, and there have been, as I said, talk out there that as much as $600,000 that people have to pay for these scarce licenses. Have you seemingly have not heard of that?
No, member guy, that would be far-fetched, because for one, the route taxi license is open, it's not closed, and therefore there's no benefit in trying to go anywhere else to get it. So all that is required is that the applicant becomes a member of a taxi association. I'm certain that you're familiar with Arakabesa Taxi Association and others in St. Mary. So once you join the association and you pay your membership fee, and it's for a year, for the most part, the associations charge $6,000 for a year for membership fee. Any mentioning of $600,000 would have more to do with the cost for insuring the vehicle than to pay for that type of license. The Transport Authority charges $15,000 for that license. It's easy to get. You can walk off the road, enter a taxi association right now, put that application in. If you want that license within 24 hours, you pay the additional $5,000. And if you want it within 3 days, you pay the additional $3,000. There is absolutely no incentive to pay that amount to get that type of license. None at all.
Member Cousins' mic is...
Thank you. Chair, Mr. Smith, is there, you mentioned that it is open, is there any limit on the number of vehicles that can be on a particular route?
Right now, the model that has been practiced is a liberalized model. So the routes are by and large open, and the competition and out there will determine the saturation point. So we have not...
No, you said by and large. I want to know definitively.
Definitively.
Okay.
Yes, so it's open for applicants to come in and apply.
And any amount can run on one particular route?
What happens is that the market out there determines the saturation point. And
not the Transport Authority, no.
Currently, that's a model being practiced. Notwithstanding, however, there are certain routes that we continue to do surveys and determine service levels on those routes.
So you don't, from a policies obviously with the ministry, but you don't make a recommendation to say we believe a maximum of, for example, 100 licenses should be issued from Papine to Halfway Tree.
We do that, and that's why I'm saying currently, and we continue to do surveys. So the indication is not that the market is saturated at this point in time, and there's no need to cap it. Because one of the things that the licensed operators will complain about is the competition against illegal operators. And in seeking to bring the illegal operators into the formal net, you give them an opportunity to regularize their operations.
Okay. Member Cousins?
Yeah, thank you, Chairman. MD, earlier in your opening, you made reference to.
Speak closer to the mic for me.
Earlier in your opening, you made reference to the hot button topic, that is the payout, being sub judice. Just want to be clear. Did you invoke that sub judice provision in terms of whether you're contemplating legal action, or is it that the matter is currently before the court? Because I'm looking at the response that was provided, and the response would seem to suggest that the matter from the agency is not yet before the court. So is the matter now before the court?
We have been served notice by the individual that they intend to bring the matter before the court. And this is on that premise that I made that statement.
Thank you very much. In respect of the response from the Solicitor General, did you receive that opinion as yet?
No, the response from the Attorney General's Department is still awaited. I checked last week, indicating that we had to be here today, but they were unable to provide it for this morning.
Just read 1 second.
All right, so thank you, Chair. I'll return with further questions. I yield to my colleague.
Member Sibley's.
Just to follow up to Member Cousins' question, was this information also communicated to the AG with regards to the matter being a
served notice?
Legitimate one, and notice was served? Was it ever communicated to the? Because why I ask the question is, the response from or the finding from the AG is one that we should recover the funds of X amount. I have also noticed the gratuity amount being withheld, and that in itself I can understand why there would be some legal challenges there. So I want to know, was this line of communication outlined to the Attorney General, the Auditor General?
Chairman, member, is it both Auditor General and Attorney General, or? Okay.
I meant the Auditor General.
Yeah, we use AG interchangeably, but here he's referring to Auditor General.
Okay, I can only say I was notified this morning when I got here that notice had been served on the authority. Mr. Smith can respond, really, Auditor General.
What I will say is that the responses that the Auditor General would quote in their report were the responses that the authority would have provided at that particular point in time. In respect of notice to challenge, it was subsequent to the Auditor General's report. And
could you indicate when you were in receipt of that?
We have, my attorneys, what we have was a letter indicating that they intend to challenge this particular issue of the Transport Authority withholding the gratuity payment. So before the Auditor General's report was issued, the authority was not in receipt of that particular position and could not have advised the AG based on that.
I know, but I'm trying to be specific. So, I mean, you would have gotten a letter from somebody acting on behalf of the individual. I'm trying to determine when were you in receipt of that letter. If you can ask your team to just check that and come back to us. Member Cousins has a follow-up.
MD, MD, the notice you received, was it from the individual himself or from someone acting on behalf of the individual in a legal capacity?
The latter.
I want to be clear.
The latter.
Someone acting on behalf of the individual in a legal capacity.
That's correct.
Hold on. Member Sibley's, then Member Guy.
So I read in your response that the entity acted upon the advice, upon legal advice prior to making the payment. Am I correct in when I look at your response, somewhere in there said it mentioned the Industrial Dispute Tribunal and that the attorney of the entity no, you never said the attorney of the entity, but you said upon legal advice the matter was settled. I'm asking you to.
Well, it's not.
If that is so.
No, what's quoted in the report is that in arriving at the decision, what the board looked at was the discharge of a former managing director, I think it was in 2016, and the former managing director challenged, as a matter of fact, went to IDT and counsel for the authority as well as the defendant, having looked at the matter, came to the conclusion that it would have been better to settle outside.
Member Guy?
Chairman, I'm getting two distinct impression here. The challenge that the Transport Authority has received by a letter of a firm representing the individual is in relation to the gratuity.
That's correct.
Not in relation to the payment of the amount.
That's correct.
Right, so that particular, in that particular situation is not sub judice as you're suggesting a while ago. It is only in relation to the payment of the gratuity. Is that so?
Please repeat for me, Member Guy.
No. When the matter was raised earlier, you said that it was sub judice. But what I'm now gleaning is that it is only the matter as it relates to the withholding of the gratuity that legal action has been indicated to transport authorities being contemplated.
That's correct.
Okay.
Member Cousins?
I'm advised that the date of the letter was December 23rd, 2022.
December 3rd, 2022?
23rd, 2022.
And since the letter, have they proceeded to take any action?
We are awaiting service of formal notice.
Because that's almost a year ago. It sounds a little strange that a lawyer would initiate a letter last December and up to now not proceed with any action.
I'm advised there's a follow-up letter. There was a follow-up letter dated January 10, 2023.
Okay. Without giving every detail, what was the gravamen of that letter?
I'll try and pull it for you, Chair.
Okay. You can speak, Ms. Williams. Let's proceed.
Okay, so the letter speaks to the outstanding final payment and gratuity due to Willard Hilton, and it is saying that the failure of the authority amounts to a breach of the employment agreement made with Mr. Hilton on November 30, 2020, which has resulted in our client suffering significant financial loss due to the unavailability of the funds. And for each day the Transport Authority continues to breach its obligation to our client, the losses continue to mount, and our client's claim in the Supreme Court will include the additional losses suffered as a result of the unjustifiable refusal of the authority to honor its agreement with our client. And
Who acts, is it the Attorney General who acts on behalf of the Transport Authority in responding to those issues, or you have in-house counsel or external counsel?
In-house counsel.
So you have responded to those correspondence?
Yeah.
Okay. So let me ask then, so given where we are at now, the letters from his counsel, your response, tell us what the current status is.
We are still awaiting the Attorney General's feedback in respect of this particular matter.
Okay, so you have sought the opinion on this, okay. Member Cousins, you have a follow-up?
Thank you, Chair. MD, not to be cheeky or facetious, but looking at the issues that brought us to this point, you're currently MD. The post was advertised. Was the post advertised when you, and you have the requisite qualifications?
That's correct.
Because we don't want to go back down this road again. So, I mean, it needs to be clear, Chairman, to the, well, I don't know if he can. I mean, one cannot be a judge in his or her own cause, but certainly the PS is there who can confirm also whether or not my questions are, you know? So perhaps the PS could respond to my questions, Chairman.
Chairman, member, I would have to inform myself. I have not examined the situation of the MD. I prepared myself for today looking at the Auditor General's report and the advice that the authority got from its legal officer, and I have referred the matter to the Attorney General's chambers for my own guidance. However, if you wish for me to provide you with a response, I will seek to inform myself and submit the information.
Yes, if you could, PS, if you could brief yourself and then provide to the committee a response on that. Given that it was flagged as an issue by the Auditor General, not of the post not being advertised, not necessarily in relation to you, but prior. We just want to assure ourselves that the agency is now complying with its own internal processes and the ministry. Yes, Ms. Williams.
I'm speaking out of turn, but I can just explain the procedure that was engaged, and I submit to the PS in terms of her review to see if it is consistent with the procedures that ought to have been engaged. So the post was advertised internally first, and that usually is a 2-week notice period for persons to apply. The board had requested that a committee, that all senior management posts be advertised externally. And the external advertisements were done also in the national papers. The board established a committee to do the review and recruitment process. So that committee was a board committee with other persons who were assigned by the board. The Services Commission was part of it, the Jamaica Constabulary Force, and other members of the board. A committee was established for that.
And I assume a recommendation made to the board in relation to the incumbent who is now in the position.
As far as I am aware, I couldn't speak to those details, that part of it, but I know that would have been part of the process of the committee established.
Chairman, your line of inquiry is quite correct. I believe it is important for us as a committee of parliament to ensure that the guidelines as it relates to employment and recruitment are being strictly adhered to. Because the reason we are here now is because of a breach in those guidelines. And certainly as a committee, we ought to ensure that we interrogate every single aspect. So it is not necessarily an attack on the current MD, but it's a review of the processes that brought us to this point. And so I've not heard anything about the qualifications and that being an aspect of the review process, but I know it was also flagged by the AG. And so we need to ensure that that is also a part of the process, because we heard of a process that involved various stakeholder groups, but did not hear of the what were the criteria and
Well,
the qualifications
what I would
established,
say though is, I don't want to get too specific to the individual. I would ask the PS to provide to us in terms of the process. Once you have briefed yourself, indicate what the process was so that we know. But I don't want to get here into that level of detail in relation to the individual.
Very well, Chairman, and I will provide all relevant information in relation to the matter.
Member Sibley's, you have a question?
No, I was really wondering, was the audit period beyond December 22? What was the audit period? Did the audit period carry through from 2017 to 2023? When was the audit period? Could you just, I know.
Mrs. Lulin, if you can answer that. Press your mic.
Thank you. Thanks for the question. Just to note that the period actually ended in 22, but where we are required to review responses and to do verifications, we would go beyond that period. And so any response that comes related to a later period, we would have gone into that.
Right, and therefore, being that my colleague had asked the question, and I think the question is live, that my colleague had asked based on your finding. Yeah. You looked at the qualification, being that you look at the qualification of the previous MD, had you look on the current qualification, and was it satisfactory to your mind? Thank you. Of the current MD. Thank you.
We would not have assessed the current MD, but in the case of the previous, we would have recognized that when you're acting, you need not have the requisite qualification. But when you are confirmed or appointed, you should, and we found no evidence that the qualification was aligned to the job that was given.
Ms. Blake, in relation to the Ministry of Finance, there are a number of allegations, 3 related to staff hired contrary to the Transport Authority's own HR policies and the Government of Jamaica guidelines. Has the Ministry of Finance satisfied itself that that has been corrected and that the process for hiring staff complies now with the ministry's and the government's guidelines?
Mr. Chair, just before Ms.
Go ahead, Mr. Smith.
Update in respect of the most recent letter we have on file from the attorney from Mr. Willard Hilton.
Okay, you want to go ahead and indicate? Okay, press your mic. Yeah.
Okay, so the last correspondence was dated August 11, 2023, and it makes reference to the previous letter on February 3, 2023. As you should be aware, claim number SU 2023CV00150 was filed in the Supreme Court of Jamaica on January 20, 2023, seeking damages against the Transport Authority. It says the claim was served, although I think our legal person could speak to that a little more. The claim was served on the authority, and the authority chose not to respond. As a result, we have requested default judgment in your letter. However, I'm going to ask the senior legal to respond to that, because I think there is some gap.
I need to guide myself, but I'm not a lawyer, but I'm a little bit cautious about continuing the discussion, given that you have confirmed that the matter is before the Supreme Court. So I would hold on this anything related to this matter because I believe we would be in breach of the sub judice rule. So let us discontinue the discussion out of an abundance of caution.
Quite appropriate, Chairman. I support that line of, yeah, it is.
Yeah.
But it does.
Can I go back to you, Ms. Blake? Can you release your mic, Ms. Williams? Just release it. Ms. Blake.
Right. Unless we are asked to give some approval, we would not be aware of what is happening. They are a public body operated by a board. So we would not know unless there is some submission to the Ministry of Finance in terms of asking for some approval.
I wasn't necessarily saying approval per se, but it would be more to ensure that the guidelines as established by the ministry are being complied with. So it's not so much approval, but whatever their practices are consistent with the ministry's guidelines.
Right. There is a reliance on the audit process, both the internal auditors and the Auditor General in terms of the audit process that would make us aware.
Let me tell you why I asked the question. If I go to page 12, allegation 3, the allegation is staff hired contrary to transport authorities, HR policies, and GOJ guidelines. And the final sentence says, as it relates to contracts for senior managers, the authority has taken corrective action. Consequently, all new contracts have since been reviewed by the portfolio ministry and approved by the Ministry of Finance. That's why I asked, because management has said specifically, now I don't know if it may not be you in particular, but I just want to be assured that this is actually so. I don't know if the Auditor General's team can confirm whether, no, to verify the response from management here. That both your portfolio ministry, which would be transport, and finance have approved all the new contracts since the issue arose. MD or Ms. Williams, I don't know if you can enlighten us. The response comes from you, but I wanted some verification of it. Sorry, Ms. Lulin, go ahead.
Yes, just to indicate, Chair, that we were not provided with the evidence. However, we are aware that the matter is still one that is being looked at, as you'd see in our prompt, where we are still keeping it in view.
Which is why I want to know where we are at now, because it is important to verify management's response here. And the response indicates 2 separate ministries that would have approved of the processes going forward. So I would ask as a follow-up, even though I'm going to ask the team to respond, that the Auditor General as a follow-up give us an indication that the recommendation and the response of management is in fact so. But I don't know if you can, yes. Well, Pierre, oh yes. Because your portfolios have changed so much, I didn't remember you were transport. But I don't know, PS, whether you can enlighten us or whether you need to brief yourself on that matter.
Chairman, that would have predated me, so I would have to brief myself before I make any commitments.
Okay.
One way or the other.
Because we obviously don't want the same issues to arise in audits when recommendations are made. Management has indicated corrective action, and we're still not sure whether those things are being complied with. Well, that's what I've asked for them, to provide an update on, because I know when you look at the prompt, some of the issues are in view, some are no further action, but quite a few of them are still kept in view. So it's important that we know, for those that are kept in view, that the corrective action is in fact taking place, and we don't come back here a year or 2 later and have the same issues arising. Members, any other specific question?
Chair, There is something that I'd like to get some clarity on. In the report, if you'll allow me, I'll just get back to it, where Chair, if you would take another member until I get my bearings correct, I would appreciate it. Chair, I draw attention to page 7, and I'm going to ask the Auditor General's Department, page 7 of the report. 3. We know that the CA, GM, HR, and A requested compensation for work done between 2016 and 2020. In a memo to the then Managing Director in December 2020, the CA, GM, HR, and A indicate that despite repeatedly requesting payment, previous supervisors denied these requests on the basis that the duties were to be incorporated in the officer's work plan. Now, this is between 2016 and 2020 that the requests were made. Was the Auditor General's Department able to determine if these requests were made on a yearly basis, how many times these requests were made, and what is the times that these requests were made? Because there is a reason why I asked that.
If I may, we saw where work was done, but as required by the policy, there was no pre-approval to determine how compensation would take place. So there could be no verification on our part that these activities really were pre-approved as would have been required, because there are various levels of payment that would be aligned to the work that is being done, and that would take place with the supervisor before you actually begin work.
Member Guide and Member Siblings, yeah.
Yes, I asked a question, but you haven't answered the question that I've asked. I wanted to know, did the department find any evidence of this repeated request being made by way of letters to the various general manager and managing director between 2016 to 2020?
No, not repeated request, only in the memo that was provided to the ministry, right, to the MD at the time, sorry.
No, why I asked the question because this is a little, based on this, there's a potential for an appreciation or a conclusion that between 2016 to 2020, there were repeatedly requesting payment and they were denied. Now, it falls afoul of the chart on page 12, which a conclusion I'm saying could be drawn from that in 2018, the then general manager in charge of HR denied that request. The general manager in charge of HR became MD in when was it? March 2020. Oh, December 2020. So I want to know whether that individual who was the general manager in charge of HR then refused that payment or refused recommending that payment to the managing director. But when that individual became managing director, that it was approved. Because you see, you understand what I'm saying? the repeated suggests that it's over the period of time that that was made. I wanted to know whether there was any document, any paper trail to indicate during the period of time when that request was made, and whether that particular GM in charge of HR denied recommending that amount whilst he was general manager in charge of HR, but subsequently became MD for the entity and approved.
Okay, if I may, I'll ask Mr. Prince to give further information.
Just release it. Go ahead.
All right, so for clarity, what we refer to here between 2016 and 2020 was the work that was done. Now, this information, we had found it contained within a memo written by one of the members to the MD at the time. The GMHR at the time, who you are referring to, would have subsequently become the MD, he wouldn't have been the one to receive the request based on information contained in the memo. It would have been the MD at the time who would have been supervisor for the member. So that is the one, that's the individual who would have refused the request based on the information that the member had in the memo. So it's not the same individual that's acting as HR that we're seeing doing the denial in the MD position.
You're saying, therefore, that the repeated in this document refers to the work.
To the work done.
Repeatedly done.
The work done between 2016 and 2020.
So it's not the request?
Not the request, no.
Okay.
The request will come in the form of the memo.
Well, it's a little untidy here then in terms of how it is represented.
Understood.
On that basis, Chair, lend me to ask the question to the agency, the public body rather. In light of the questions that was asked by my colleague and the answers given by the Auditor General that says that work was done. They are not, the finding is not about work that was done. The finding is the procedural steps that should have been taken. The pre-approval, the subsequent approval after the work has been done. Has that been corrected? Because this could cause a big issue if workers who are, whether they are represented or not, take this matter further, because the procedural steps is not necessary for the worker to ensure, but it's for supervisors and the other, the agency to ensure that these things are in place. So I'm asking, are they now in place, and how well those controls are being functioned?
Thank you, Member. What I can affirm, Chair, is that those steps are well in place. One of the things we want to do is to ensure that our policies and our systems are airtight. So we are learning from the report in terms of whatever missteps or errors there were, and we're ensuring that we tighten all those gaps. Suffice to say, however, that prior to the payout to the members, that the former managing director had in fact written twice through the office of the then GMHR to the Ministry of Finance and got no objection in terms of the payouts.
One second. Let me just allow Ms. Lulian. Yeah.
If I may just clear up an issue, though. In a letter that was sent to the compensation unit from the Transport Authority, it says that, however, the uncertainties surrounding the situation in whether prior approval was granted for this payment of allowance by the ministry is required, as there is no evidence on file regarding approval as this allowance is not mentioned in the staff order. So from the letter, it is clear that there was a recognition that prior approval was needed. However, there was no indication on file that they had, in fact, sought prior approval.
Wait, Member Williams?
Yeah, if it pleases you, Mr. Chair, well, probably a question to the MD. So I'm just trying to understand here. So in relation to these payments for work done or additional work, special allowance, you know, in whatever way we may want to formulate it. You're saying that before the payments were actually made, that clarification and approval was sought from the Ministry of Finance?
Yes, the Transport Authority did in fact receive a no objection letter from the Ministry of Finance in terms of the payout.
Okay, so I don't know if I'm, so my next question would be, so did the Ministry of Finance alert or provide any comment on the protocol or the approach? Was it just a blanket approval to say, okay, we have looked at it, work was done, it is justifiable, the payments can be made? Was there any kind of soft admonition, I would say, from the Ministry of Finance that in future, these pre-approvals, these payments are to be made in such a way, or the arrangement for the work must be made in a particular way? Just a query.
Not from what I've read here.
Okay.
Go ahead, Member Siblings.
It's a special allowance, you know, but I am not sure what it is. The nomenclature that is being used is special allowance. Is it, to my mind, special allowance means something that you do not work, is because of a certain situation, you are given an allowance. But based on what is said by the auditor, it said work was done. So even though it is denoted by name as special allowance, it is tasks that are done that is being paid for. I just want to make sure that is very much cleared up, because special allowance denote something else other than tasks that were assigned and were done. And I'm hearing tasks assigned were done, and the procedure in which those tasks were to be approved prior to be done was breached. That is what I'm hearing. So can you clear that up so that, to my mind and others who might be confused as I am, that even though it is called special allowance, it is really a task that is being done.
Thank you, Member. As you'd appreciate, just like the PS, I've inherited this report, and my understanding that these were special projects and came under the broad banner of project premiums. And insofar as the works were carried out, but the appropriate steps to pre-approve the payout was the issue. And consequent on that, the Ministry of Finance was written to, and no objection was obtained in terms of the payout.
Okay. Member William? Wait, one
Yes.
second, Member William. I think Mrs. Lulim.
Just to clarify, though, that the ministry in their response said they had no objection if it was consistent with their HR guidelines. So the guidelines speaks to prior approval.
Okay.
So I wouldn't say it was a carte blanche, you know, objection, no objection by the ministry.
Okay, thank you. Member Williams?
Yeah, perhaps I should have asked this question as a follow-up when I tabled my first question to the MD. And I'm happy Mrs. Lulim raised that point, because I'm looking at page 7, paragraph 3, but I'm just wondering if that Ministry of Finance approval, if it would have been, first, if it was brought to the attention, or if the AG's department was aware of it, one, and two, whether it would have been instructive or of some value to have included it in paragraph 3 here to say that notwithstanding the fact that you unearth a particular, well, to say breach of HR policy, notwithstanding the department, the Transport Authority, did seek approval from the Ministry of Finance, and that the Ministry of Finance approved the payments. Because you see, in fairness to the authority, it seems they had made some step to regularize and ensure that the payment was above board, and I think they would have benefited. Not that I hold a brief at the authority, and I'm not thinking that it would have been, useful to include it in paragraph 3. Just a thought.
If I may, it is actually in the body of the report, but what we are talking about is approval being requested after the work is done, but before payment is made, which is a different approval than prior approval to have these special projects.
Understood. So what I would, in the follow-up, I would expect that going forward, in a scenario like this, you would seek the approval prior to the work so that you are on solid ground once you have made the payment. Member Guy?
Chair, the member just now spoke to page 7.3, but if you read the final paragraph of sentence in paragraph 4, and it's speaking to payment for work done, but albeit to 2 other officers. There is no evidence that the supervisors at the time in assigning these duties considered these to be additional to the officers' regular duties, and that the respective officers raised any concern that these duties should qualify for the payment of special allowance and project premium. Now, Chairman, you look at payments of $5.3 million and $14 million between March and June 2021. So you're looking at a 3-month period wherein officers who their supervisors did not consider it to be additional work got a payment of $5.3 million in one instance and $14 million in another instance for 3 months' work. What was this type of work? What's the nature of the work that was involved? And how does one justify that amount of payment?
I'd ask Mr. Smith.
Chairman, the payment was not in respect of work done for 3 months. Could not have been. It was over a 4-year period.
Okay. The issue, though, that still arises unresolved, though, is the fact that the supervisors at the time didn't consider this to be outside the scope of the individual's normal responsibilities, but the managing director made approval nonetheless.
Yes.
No, man, read. I'm on page 7. Let me read the paragraph. Similar payments totaling 5.3 and 14 million were made to 2 other officers between March and June 2021. These requests and payments were all made after the managing director assumed office. In both instances, the purported additional duties were said to have been undertaken prior to the commencement of the tenure, December 1, 2020, of the managing director. There was no evidence that the supervisors at the time, in assigning these duties, considered these to be additional to the officers' regular duties, and that the respective officers raised any concern that these duties should qualify for the payment of special allowance and project premium. So that's what I'm asking to reconcile. In the one instance, the supervisors considered this normal work, but something compelled the managing director, or he made a decision to make that payment nonetheless. Let me just allow Ms. Lulim first.
Sorry, just to clarify, it's the managing director who returned, or the individual who returned as managing director who chose to make the payment.
I know, I'm not focusing so much on the individual, right? Yes, Member Siblings.
Yes. My understanding of the paragraph, Chair, not taking anything from your question, but my understanding of the paragraph is that the auditor says there was no evidence that the supervisor at the time. Therefore, what I want to ask the auditor, was any inquiries made, being that they didn't find any evidence? But were there any check made to say whether or not that the officers concerned worked outside of their normal duties? And was there any check made with the current officers or supervisors who would be in a better position to tell you, because they are the ones that are there, to tell you whether or not these persons in fact were, notwithstanding that there are no evidence, because no evidence might mean that persons who ought to write up certain documents, sign certain documents, didn't do it, and therefore you as auditor didn't see any evidence. But what we want to know, if upon checking, upon not seeing any evidence, if any inquiry was made to the fact.
We actually made inquiries of HR, and there was no information provided to verify that, in fact. The supervisors had discussed and agreed that the payment or additional duties were being assigned outside of their normal duties.
Ms. Williams, you want to respond?
Yes. At the risk of, because I'm one of the persons who received payment, and I was also the person who was the general manager of HR when the audit was being done. And I sense that that is a little inaccurate in terms of what is being said just now. So I just want to bring some clarity to the matter. And I will do so by giving an example so you can judge for yourself. At the time, the managing director was the supervisor of all the persons who did not receive payment for additional duty. In my case, the additional duty that was assigned was an entire unit. And I was told that this unit was now my responsibility. Now, I am not sure how you can assign an entire customer service unit to one person and say that is additional, it's not additional responsibilities. So I'm just giving an example. I think that if needs be, there should be some further review of all the matters. In another case, the senior legal officer was assigned the responsibility of managing the Halfway Tree Transport Center, which was now assigned to the authority. The authority took over the Halfway Tree Transport Center. He was now the person who should supervise and ensure there were staff there, but he now had that accountability for the Halfway Tree Transport Center. So these are some matters that I think require further review, because I think in the way in which the report is written, it would give the impression that somebody just got 2 reports to do or a little project to do. It was matters of a large matter. In this case, the then general manager of HR became the managing director and would have been recipient of complaints from the individuals who were involved about the matter. So he would have been at that point their immediate supervisor and would have known and been able to verify the quantum of work that was being carried out. And I humbly submit that while I don't want to seem defensive, I would like for just an independent review of the nature of the work that was carried out, so that this committee can properly have an impression of what it is that was assigned.
Thank you for your intervention. And I just want to highlight why it is very important during this audit process for documentation or that type of information to be provided, so that what is reflected in the records in terms of the report to Parliament will reflect what you said, because what you have provided, I don't think was provided to the auditors. It was in writing?
Writing, but I know I spoke to several of the gentlemen sitting here in terms of some of the responsibilities.
No, I think in issues like this, you have to document it and ensure it is there on the record so that whatever is provided, because the Auditor General said no evidence and made inquiries and didn't get anything specific. So it's very important that you have documentation there. I have member Sibley's. You're yielding,
Yes,
member Sibley's?
No, no.
Oh.
I agree with you, Chair, to the extent that good management reduced every meeting that you have to writing. I am not absolving any auditor of not recording their own interview with an auditee, because they ought to. But for good measure, you ought to reduce your own minutes of any meeting that you have with the auditor. You can thank them for interviewing you and just say what you recall from them interviewing you. Now, like the chairman, I thank you for really explaining, because when the chairman read the paragraph, I can understand why he would have come to that kind of conclusion, right? But the fact of no evidence raised a red flag in my head that it, notwithstanding that the auditor said that there is no evidence, I wanted to know whether that means that the work wasn't done. And you rightly put it, and you come forward and you said these are the things that were done. And I accept them as a member of this committee as work being done. I do not agree with some of the assignments that were being done, but I'm just a member of the PAC.
Member Clark.
Thank you, Mr. Chairman. I just want to add my voice to the situation that here it is that you're doing an audit. It's an external audit.
If it's a what?
It's an external audit.
Yes, by the Auditor General.
Exactly. I just want for it to state it. And so if I am a member of the AG's department and I go there to do an audit, it is, the onus is on me to make sure that I capture all the information that is going to be presented or is going to be said. And therefore, what Madam Williams would have said to us no gives me the feeling that that is a evidence that was provided but was omitted.
Well, I can't say that. I would allow...
No, it is my opinion.
Oh, that's your opinion.
It is my opinion.
Okay, that's
it is my opinion, not factual. And based on what her response was to us just now. And so the whole argument of giving one person who has an assigned duty another that should have been done by another assignee tells me that it's not just, by the way, just get this done for me. It's something that takes a process over a period of time. And so even the wording of this paragraph leads me to wonder what next, or what was left out of it.
All right. Well, before Ms. Lulim, I would say this though, and that's why reducing things to writing is important, because if you are being assigned something like taking on a new department, your supervisor should put that in writing to you on your file to say, I am asking you to take on these ABC responsibilities. And as such, you are going to be compensated a special allowance of XYZ. That clearly wasn't done. And even though I know you verbally provided it, is important even at the end in an exit interview. Because remember, you have a process, the auditors come in at the end in an exit interview, you pick that up and say, listen, this is not totally correct, and as such provide it. 1 second though, let Ms. Lulin been waiting to come in here.
Thanks, Mr. Chair. The issue is this. We look for evidence on records. There is no evidence on the records that the supervisors considered it additional duties. No. And secondly, when in any discussion, we do take interviews into consideration, but the interviewee must also present evidence that what they say is in fact the truth of the matter. And we saw no evidence, we received no evidence from the person. So what it means is that we went back to the files to see if there was a misrepresentation, and we saw no evidence where the supervisor had indicated that this is the additional duty that you are required to do. In fact, in a situation where there is a prior discussion that duties are to be assigned, then that prior approval would have been given, and the person who is doing the job would have accepted that these are my responsibilities for which I will be paid. We saw no such evidence.
And I understand the issue here. I take what Ms. Williams has said at face value, and I believe it to be so, but there's a difference between a verbal thing and something in writing. And I think there are lessons to be learned going forward that if another situation like this arises, then we just follow the proper procedure so that we don't end up in this thing. But Ms. Williams, you want to? Sorry, 1 second. Sorry, let me allow Mr. Prince.
Just to go a little bit further, in the member's memo written to the GM, to the MD at the time, the member indicated that the previous MD did not view these duties as being separate and apart from what should be incorporated in the member's work plan.
All right, I'm going to allow you, but I don't want, given that you are one of the affected individuals, let's just accept there was administratively some gaps that the Transport Authority should have filled, and let's ensure going forward, because it can create a reputational issue for you. And I understand why you reacted the way you did. And frankly, reading it without more gives a particular impression which would not be favorable. But let's accept that we have to treat with these matters in a more formal way and have the documentation so that the auditors would have that evidence going forward. Member Sibley's?
Chair, I don't want to add much to what you have said, but I concur with what you just said and want to re-emphasize the point that, it is your responsibility as employees as well to document these things, and I agree with the Auditor General's department in what through the deputy, which is central. What she has said in auditors going about seeking to verify the first port of call is document, and I would imagine they would have accepted even where you would have written to them to outline, just as how you have done now, because we don't see it in the response, just to detail it and whatever correspondence you would have had to provide it, because that is what we are hearing. And so, but I thank you for going into detail today and letting us know so that we can leave here having a better understanding of the gaps. Thank you.
Member Clark?
Thank you very much, Mr. Chairman. In all fairness to Transport Authority and its member, what caused the space to be made available, as in the job that they were reassigned. We don't know. We haven't seen it. But the MD at the time decided to ask a person to oversee these two departments. Reason being, the space is available. You have to go through a process to, and it is my opinion, you have to go through a process to advertise and to interview and to hire. But the work has to go on. And so you couldn't leave it up in the air like that. Somebody has to do it. And so it is my opinion again that the AG department could have, in the paragraph that is put before us, because we are here to vet and to assess and to come up with policies, right? And I think it is my opinion that just to say that in the interview, this was said by the interviewee, but we found no evidence on paper, no written document. So you have the verbal, but you don't have the written, and so it gives the reader the space to say, okay, something was said, but they still need to follow.
Point taken. But as I said, let's treat this as a lesson, not just for you, but for all MDAs going forward, that if we have similar situations like this, that we ensure proper documentation on both sides, both the employer and the employee, so that we don't have this recurring. Remember, Guy?
Here, could I just one final thing. I do recall that in the initial part of the presentation by the Auditor General's Department, that the deputy said that we saw that work was done. Am I incorrect? We saw that work was done, but we did not see any evidence of compliance with the policy,
Right.
which is basically the gravamen
Of the
is
issue.
the
Yeah.
issue right now.
Okay. All right, members, do we have any further questions for the Transport Authority and the Ministry? All right, let me thank you for being here, and you can take your leave. I'm going to ask the auditor, 1 second. Yeah, member Guy.
We have some matters that they need to get back to us on.
Yeah, let me, so just to be clear, really for the Auditor General there are a couple of things that I would like, and also the Ministry, the verification that the contracts for senior management, those contracts are compliant and have been reviewed and approved by both the Portfolio Ministry and the Ministry of Finance. That is on page 12, the management's response. And I believe it would be also important once you have received the opinion from the Attorney General's Department to indicate where things are at with that particular matter, so we know. Because a letter was read out, and I'd want to know what has happened since then, and once you receive that advice. And if the Auditor General could provide an update as well, there were a couple of matters that were being kept in view, just to provide a status update for us on those. All right. Thank you for being here. I'm going to ask the Auditor General's Department and the Ministry of Finance to stay, but you can leave. Thank you.
Thank you, sir.
Thank you.
Members, at the last meeting, we had requested of the Auditor General's Department an outline of the process. Once the Auditor General commences an audit, we have been provided with a document. I'm going to ask Mrs. Lulim to take us through. I assume you have it? You don't have it? No? It's a one-pager with 2 sides, which indicates your process: commission letter, entrance, meeting, fieldwork, etc. You can give Ms. Blake one. I was going to ask you to just go through quickly with us the process, and I know members will have some questions. And this was circulated to us, so we would have it here. It's a one-pager, this one-pager on both sides, which outlines the process. Yeah, man, it should be in your documents. It's separate, that's a one-pager. Yeah, man, it should be there. Yeah, that's it. Okay, Ms. Lulim, if you could just take us through the process.
Thank you, Chair. Okay, in the first instance, in fact, before even this commission letter, as you will see in number 1, is actually sent out, we do a preliminary assessment, and we normally contact the entity to indicate that we are considering an audit. However, we would like certain information to be sent to verify that we will go ahead. Now, having done that, if it is agreed within the department that it warrants an audit, we actually send out a commission letter which indicates to the entity their responsibilities and the responsibilities of the Auditor General. It also is accompanied by an abridged study plan, and in that study plan, it will give you the audit objectives and the methodology and the time at which we intend to commence our entry in terms of our entrance meeting, which is in fact the first day of field work as well. So we will have an entrance meeting, which we would have indicated in that letter. The entrance meeting can either be face-to-face or it can be virtual. But at that entrance meeting, we also expect, and we normally get questions regarding the process and any issues that the auditee would want us to answer in terms of the material that we will be looking at and the officers that we would wish to have interviews with.
Just for my clarification, and this takes place for all audits, regardless of the nature of the audit?
Not for all audits. There is a different methodology for special audits.
That's where I was going, because I would think you'd have to operate differently based on, okay.
Yes, because even in terms of the special audit, there are issues and allegations that we would want to look at before we actually meet with the entity. So this is really for performance audits and, generally performance audits. We use a standard PowerPoint presentation which we make available to the entity after the meeting, and that will give them an evidence, some type of evidence as what we would have gone through in terms of the initial entrance meeting. And there are also opportunities as well, even after receiving that PowerPoint, where they may seek clarification if there were issues that they still need further information on. But as I indicated, that entrance meeting really starts the first day of our field work. And once that is established, once the field work commences, there is constant dialogue between the auditors and the auditee. And in fact, the representatives that would have been indicated by the audited entity as the main contact persons. So that would be taking place at the fieldwork stage. Once we have done the fieldwork, we have on the final day of that fieldwork an exit meeting. Of course, prior to that, we would have provided the entity with a first response matrix. And that response matrix gives an idea of our findings and as well as the outstanding documentation, areas that they still need to clarify. So when that entity comes to that exit meeting, they will come armed with their questions or with additional documentation or clarification of the findings that would have been provided in the first response matrix. And at that exit interview, there are opportunities for feedback again, discussion, and clarification. Within 10 days of that exit meeting, we will seek to provide a draft to the entity of our findings, which would incorporate all the information that would have been provided prior to the exit, as well as information shared with us at the exit, as well as any other information they would have shared with us or any audit evidence prior to the preparation of that first draft report. And in fact, that first draft report would be an opportunity for that entity to see whether or not there were things that we missed or whether there were gaps that we did not identify, or even then, evidence that they have subsequent to our discussion that they were not aware of but would like to elaborate on. As indicated, that draft is also sent back to us with a response. So they are required to respond to us having reviewed that draft report, as well as provide additional documentation if necessary. There is constant communication even prior to that, whether verbally or in emails, where they would indicate the additional information that is being provided, and we would identify outstanding information. At the end of that process, where we have no further information and the entity has provided no further information within a time frame, we will produce what you call the final response matrix, and that final response matrix will again include all information that would have been provided post the draft report, as well as the key findings that would have been presented in the draft report for the entity to sign off page by page to indicate that they are in agreement or they're not in agreement. We would have been indicating also in that final response matrix what evidence they have provided that requires further information or is just not acceptable because it doesn't meet the standards of audit evidence. And so that would come in the final response matrix. Once the entity is, once the entity reviews that final response matrix, and I say sign page by page to indicate, as well as on occasions you would find where some entities will even send an email, to indicate that they do have further information if we can consider it. We take any opportunity to verify any additional information that would have been provided after the final response matrix. Then, or on receipt of all of that, we would have prepared or finalized what you call finalizing the draft, because it's really only the Auditor General who has the authority to sign off on any report. Now, their response matrix, along with our revised draft, is actually sent to the Quality Assurance Unit for verification, whether it be the numbers or cross-checking information we have in the report that may be conflicting so that we can ensure that the Auditor General has a document that is fully verified on our part. When that document is sent, is completed by the Quality Assurance Unit, it's the unit that actually sends the report to the Auditor General. The auditors really have, once they're finalized and put in the corrections, have no further contact with that document. So the Auditor General would now review the response matrix along with the quality assured report, and that's what goes to the Auditor General. 3 days, at least 3 days prior to the tabling of a report, we will seek to share the final report with the entity as well as the permanent secretary. In fact, the commission letters and all of that would have been shared with the permanent secretary.
I was going to ask that question, whether
all correspondence.
the first time, if
Yes.
the first
No,
time the PS
no.
was seeing this
And if
would be
no.
at the end.
Right. All information regarding the plan for the audit, you know, that would be reflected in their
Well,
books
all right,
would be shared with the permanent
The
secretary.
main concern I had, which you are addressing, is really between 9 and 10. If the PS is brought into the loop earlier, I think it needs to be
Yeah.
explicitly
Yeah.
stated, because 9 really is the first stage that I see the PS explicitly.
Oh, okay.
So if the PS is
Yeah,
copied,
from the very beginning.
well, I think that must be
In
stated.
fact, the commission letter on
It
occasion.
says it at 5?
Yeah.
Oh, sorry. Yes, no, you're correct. And then I would say that 3 working days between submitting to the auditee and the permanent secretary is woefully inadequate, right? Unless you're only providing it to notify them. But if it is being sent to them for either review or comments, 3 working days could never be sufficient for somebody to read a document which is lengthy and then give you a response.
But
yeah.
they would have seen a copy of the draft report.
Yes, true, but equally, this is the first time they're seeing the final. I mean, they have seen drafts, and drafts can change. They provide responses, etc. But I think in a case where you are sending something to Parliament, I believe the auditee and the permanent secretary should be given at least 7 days minimum to review the report and to say, listen, you know, all right, I've seen the draft, etc., but I really do agree, I do agree with this, or etc. The 3 days is insufficient from my perspective, and I think should be extended, even though the PS is involved in the process a little earlier. Because draft, as we have seen in one of the cases, there are significant differences between draft reports and final reports, right? So that's the one area that I believe needs to, that 3 day need to be lengthened to provide enough opportunity for, you may not change it, you know, right? But at least the auditee can say, I was given that report, which is the one you're sending here, and I've had an opportunity to make my comments before it actually comes here for tabling.
Just to note, though, that even in recent times, we have actually adjusted a report based on feedback from the entity who would have shared the information with the permanent secretary. And in fact, they may not have received the adjusted report, you know, after that 3 days, but we would have taken into consideration their response and adjusted the final report for tabling. So, but I take your point that maybe 3 days.
No, 3 days is definitely,
tight.
no man.
Yeah.
And I mean, PSs are exceedingly busy people. These reports can be 100 pages or more. And I know why people feel their stewardship is under review. And they certainly need an opportunity to see a final. Even if no changes are made, they can say, listen, I have an issue with this that you raise, or that opportunity should be provided, and a longer period. Members, Sibley's?
Thank you, Chair. I agree with the Chair that 3 days is inadequate. In fact, I know places that give 2 weeks and provide also that if the head of entity asked for an extension and state the reason that they are asking for extension to obtain a particular document from a third party outside of the entity's control in order to provide the auditor with evidence. So I agree with your chair in that respect. Chair, I note when you ask the question if this process is for all the audits that you conduct, and the Auditor General's department response was that no, because clearly this does not take into consideration public bodies. And if it does, let me finish.
Yeah. No, if I may, when I say the entire process, what I'm saying is that we have an entrance meeting, say, for a special audit. We have a response matrix and a final response matrix and an exit. However, the interaction that would take place, say, at the exit interview is a little bit different because we do not, I don't know if we use the template for a special audit, but it's really a discussion. But just also to note that in all instances, at every exit, the head of department is always there. As a matter of fact, the head of department usually has additional information that they want us to incorporate and for us to consider. So the head of department is always there. In the case of the special audit, we may even have additional discussions outside of the exit interview to clarify. So when I say it's not the same for performance audit, it's a little bit different. But for the special audit, there are areas where we may alter that interaction because of the nature of the special audit. Sorry about that.
So, Chair, I want to put on record, therefore, that I do know, based on my reading of the law, that for public bodies, the law detail certain things, and I'm not seeing it here. And I just want to place it on the record based on the Public Bodies Management Accountability Act and also the FAA Act, that it does prescribe in details some aspect of the procedure of the Auditor General. And so when you spoke earlier to say no, that this is just not for every audit, right? I can clearly understand these procedures for MDAs. And it is in line with my own thought and my own reading with regards to section 1 to 29 of the FAA Act as it relates to MDAs. But I am sure that this would not be compliant with section 30 of the FAA Act and section 13A of the Public Bodies Management Accountability Act. And so that's why I asked.
What I would say, member, I just want to be fair to the Auditor General's department. The request we made was a process request generally about audits, performance audits. So I think you're correct in terms of the law, but we didn't request that of the Auditor General's department, just to be clear. So this was really just to, coming out of the last meeting, there were concerns about the process. But go ahead.
If I may also, you will see here where we speak about an abridged study plan. We wouldn't have an abridged study plan for a special investigation. So I take your point, you know, because it's allegations
Right.
that we are pursuing. With the performance audit, clearly you have the study plan which looks on the risks that you would have considered and all of that as well.
Members, any further questions for the Auditor General's team? All right, thank you very much. At this stage, we have reviewed the reports which have been tabled before us. There are no outstanding reports at this stage, so we will adjourn for a date to be determined. Can I have a motion? So moved by Member Sibley, seconded by Member Wilson. Thank you, everyone, for being here.